Good morning, everyone. This is the 20th public meeting of the Post Commission. I welcome all those in attendance today. We will today ask that all of the public questions, which will be monitored by Attorney Lon Povich, let me inform you that they will be held until the conclusion of the meeting and that they will be addressed at that time. And I think with that, turning to the agenda, commissioners, may I have a motion for approval of the minutes of our May 3rd, 2022 meeting?
So
I'll
moved.
make the motion to approve the meetings from the 23rd of
I
June.
think that was a joint motion by Commissioners Ellison and Kasserosian. Is there a second to that motion?
A second.
Thank you. And I think with that, let me go through roll call vote in alphabetical order. Commissioner Bluestone, do you approve?
Yes.
Commissioner Calderon,
Yes.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes.
Commissioner Kasserosian,
Yes.
Commissioner West,
Yes.
Commissioner Wynn,
Yes.
as do I. It is, the minutes are unanimously approved. Thanks to Attorney Annie Lee, who prepared the minutes in conjunction with our secretary, Commissioner Kasserosian. I think with that, we will turn to item number 4 on our agenda for today's meeting, which is addressing the recertification regulations. And I turn now to Attorney Povich, Attorney Macarius, excuse me, and to our general counsel, Randy Ravitz, please.
Yes, Randy will take us through this. So.
Thank you. I'm having a little trouble sharing my screen. Here we go. Just give me one moment. I'm sorry that
Does Maurice might be able to share the screen, Maurice or Jamie? Oh, you are now given the host, Randy.
okay.
You can share now,
Okay.
or ask someone else to share.
Okay. This should. Okay.
There you are.
Thank you. Okay, I will just go through the highlights of this document, which is a draft of a set of regulations that I'm expecting that we likely would not ask for a vote on in this meeting, but would ask for a vote on in the next meeting. And this set of regulations governs the process for handling applications for recertification, focusing on those officers who are required to seek and obtain recertification during this round, meaning by July 1st of this year, in order to avoid seeing their statutorily provided certification expire. And this set of regulations, and I appreciate the work of Anderson and Krieger on this, should seem consistent with what I presented at the last meeting regarding how these applications would be processed. So there's hopefully will not be any surprises. I will scroll through now and hit on the highlights of this document, which has been previously circulated. Section 702. Section 702 provides for the recertification process to begin with certain direction given to agencies through the executive director. It also provides for agencies to obtain extensions of time and for a simple procedure for the granting of extensions of time. And it provides that even when an extension of time is sought, a certain type of application is provided. Namely, it's an application in the form of a roster of officers for whom the agency intends to seek recertification. And that's significant because both our statute and a provision of the Administrative Procedures Act that we're relying on both refer to the submission of an application, and in particular provide, as I'll discuss in a moment, provide for the period of time given to an officer, the period of time in which an officer is certified to basically be extended or not to expire when an officer has submitted a timely and sufficient application and that application is being processed. So section 703 deals with that concept that I just mentioned, namely when a timely and sufficient application is pending. And in the past, I had used the term tolling for this, or the phrase stopping the clock. But basically the current certification period, meaning the certification period granted by the session law automatically to officers that is set to expire on July 1st, will not expire on July 1st. It'll be extended during the period of time when the certification application is being processed. And that's rooted in a provision of the Administrative Procedures Act. And there are additionally some common law principles as well that could be invoked. Section 704 provides that an officer shall in certain circumstances and may in other circumstances be conditionally recertified, and particularly where the officer could not be fully recertified due to circumstances beyond the officer's control. So that could be that the officer could not be found to satisfy certain requirements due to matters beyond the officer's control, or the application could not be processed by us, but it's not through any fault of the officer. And it provides that the original certification period, again, the one granted by statute, is extended during that new conditional period. So you might be asking, well, does that mean that there would be a period of time when the officer's original certification period is running and they have a new certification period at the same time? And the answer is yes. And part of the benefit of that is that because the statutory scheme is new and these steps that we're taking are all new, this provides an added degree of protection for the process and for the officers. Basically, a belt and suspenders approach, giving the officer two forms of assurance that, and the public two forms of assurance that during that period of time, the officer does in fact possess a type of certification and therefore can lawfully perform the activities of a law enforcement officer. Now here are the highlights of section 705, which deals with determinations of character and fitness. First, it provides that those determinations at the agency level and then by extension at our level can take into account a wide range of information and characteristics, including on-the-job and off-the-job conduct. It provides that agencies may be asked to substantiate positive assessments, meaning an assessment that somebody does possess good moral character and fitness for employment as a law enforcement officer. And so they should retain information on that regarding that assessment. But that if they provide a negative assessment, so in other words, that the officer does not have good moral character, is not fit for law enforcement, they must provide an explanation and they have to cite specific conduct. It also provides, as the commission has decreed previously, that officers will be given an opportunity to respond to any such negative assessments by their employing agencies. Then the certification division would take into account all of that information in making an initial determination about whether this criterion is satisfied. And in doing so, it can look past certain alleged conduct, meaning that it can find that certain alleged conduct does not require a determination that an officer lacks good moral character and fitness for employment. And that can happen where an authority has already made a relevant decision, meaning a decision on the conduct at issue, a decision that was in the officer's favor. So in other words, finding that the officer was not at fault, for example. Certain conduct can be looked past where there's a relevant investigation or adjudication that's pending. So in other words, we don't know yet the outcome of that. Or where the officer has complied or is complying with a decision regarding the conduct at issue, the conduct that's been cited by the law enforcement agency, and the officer has not since then engaged in any similar conduct. Another situation where certain conduct can be looked past is where it did not result in any type of disciplinary action or any court action, and there's no good explanation for why that was. The idea being that then the allegation of conduct is questionable for that reason. It becomes suspect for that reason. And there hasn't been an opportunity previously for the officer to respond to any charge regarding the conduct. And then finally, where the allegation is not specifically and credibly supported. Scrolling down, we arrive at section 706, which deals with the evaluation of different standards. And you might recall last time that I basically broke things down into 4 categories. And those categories are reflected here as well. It's just this list under section 706 goes one by one. It takes each of the criteria and addresses how a failure to satisfy that criterion will be handled by the commission. But that 4 category structure is still reflected here. So the first category is where there was an inability to satisfy a requirement, but that's attributable not to the officer, but to the employer or to the MPTC or the commission, perhaps because a certain standard has not been established yet. And then there'll be a conditional recertification with a sufficient allowance of time for the officer to satisfy that requirement. The second category is where there was an inability to satisfy a requirement, but the officer has been given less time than other officers to satisfy that requirement because of where the officer falls in the alphabet. And then there'll be a conditional certification allowing the officer time to satisfy it until July 1st, 2024. In other words, putting the officer at the beginning of the alphabet on a par with officers at the end of the alphabet. The third category is where there's an inability to satisfy a requirement that existed previously. And so there's less leniency because it existed previously. And so there'll be a conditional certification with a relatively short allowance of time. And the fourth category is where there's an inability to satisfy a requirement, but the officer should not be given a chance to cure it or maybe cannot cure it. So for example, failing a background check, failing a character and fitness analysis after the full process has run its course. Then in that case, the certification would be unrenewed and allowed to expire. And I do use those terms deliberately, unrenewed and allowed to expire, not decertification, because that would not result in all of the consequences of decertification that are provided for in the statute, including essentially a permanent bar on working for any law enforcement agency in any capacity. It would not include that, but it would mean that the officer can no longer continue working as a law enforcement officer while that there is no certification in place. Then scrolling down, the next set of sections are sections 707 through 710. And here are the highlights of those sections. They provide that the certification division will evaluate the application and provide notification to the officer, as well as the officer's collective bargaining unit and the officer's employer of an initial decision. And that a grant of certification anew is retroactive to the prior expiration date. So this is another example of where in certain ways that we are being extra careful to make clear to the officer and to the public that even if there was a period of time when the officer's application was still being processed after July 1st, if the officer is certified, then there's no question that during that time, the officer was lawfully entitled to exercise law enforcement powers, and the powers that the officer exercised should not be challenged on the grounds that there was no certification in place. These sections also provide that the commission can still limit or restrict the certification, or can limit an officer's ability to reapply if the officer did not get recertified in this round. And so it basically just preserves powers already possessed by the commission. It provides that the officer can seek review by the executive director of a decision that's adverse to the officer, even if it's a conditional and based in its form. And then if the officer is still not satisfied, the officer can seek further review through a hearing under the Administrative Procedures Act and the regulations that the commission previously adopted. And then finally, that if a recertification is for some reason vacated, so in other words, the commission changes course for good reason and finds that a recertification was unwarranted, the period of time that the officer was certified up until that vacation of recertification is not nullified. So in other words, it confirms, as I said a moment ago, that during such time as the officer was in possession of a certification, the officer's actions should not be challenged on the grounds that the certification was unlawful or was later rendered null and void. As long as it was in place, it was valid. It's only after that it ends. So if there are questions about this, I can entertain them. I will say that I'm sure that people will have certain edits and suggestions between now and the next meeting. So assuming that we're not going to be asking for a vote on this at this meeting, there would be an opportunity for some small changes to be made. And those changes would be highlighted at the next meeting.
Randy, thank you very much for your very thorough explanation and for all the work that you've done with these draft regulations. Also, many thanks to Counsel at Anderson and Krieger for their assistance in working with you. And I wonder if we could just, so that I can see all the commissioners, can we stop the screen share? Yes, thank you very much. And let me say to members of the public, please put any questions that you may have in the question answer format. We're not using chat today. And your questions, as I said, at the outset of our public meeting will be held until the end of the meeting. And then Attorney Povich will identify who is asking the question and will mention the question, and we will attempt to respond to it at that time. So I think with that, as Attorney Ravitz said, I turn to my fellow commissioners for any questions or comments that they have on the regulations. And I think I've seen Commissioner Ellison's hand. So I think we'll start with you, please, Commissioner Ellison.
Good morning. Thank you, Madam Chair. Attorney Ravitz, when you explained about the expiration, allowing the officer's certification to expire, what is the time frame on that? Is because it puts them in limbo for an undetermined amount of time. Is there an amount of time that we would have to get back with some type of resolution so this isn't hanging?
Commission to sorry, I see that the recording stopped for a minute. But the Commissioner Ellison's question, as I understand it, was whether there was essentially a deadline for the commission to render a decision on an officer's certification so that there's not too long a period of time when the officer has to wait for a decision. And these regulations do not provide for that. That's something that the commission would not be precluded from adopting less formally on its own as a supplement to these regulations. But there is some benefit in not locking the commission into a set deadline, I think, where this is the first time that a recertification process and something following these regulations is being done. And so there's some inherent uncertainty about how long it will take. But at the same time, there are, as I said, procedures built in so that during the time that the recertification application is being evaluated, the officer will be in possession of a type of certification. And if ultimately the officer is found not to be entitled to recertification, that period of time that the officer was in possession of that certification while the application was pending, that should not be challenged on the grounds that the officer was basically acting without authority. The officer will have had all the authority that the officer needed during that period of time.
I guess, Randy, I guess a follow-up is I'm a little confused, is that on the question of the license being allowed to expire would indicate that there is some problem in the system with this officer. That's not the ones who are certified, but the ones where you said that if their license would be allowed to expire and not renewed, would indicate to me that there is a problem with their certification coming up from the normal process. That's why I was asking about the timeline.
Right. That's what I was referring to. There was a situation where the commission found that an officer should not be recertified.
Right. That's
that the criterion are not met. So in other words, that would be the result, is that the officer is not recertified, and the expiration of the original certification that was granted by statute, that expiration is allowed to take effect. The original certification has now ended at that point. But as I said, I deliberately phrase it in that way as opposed to saying that the officer is decertified, just so that it's clear that the officer is not subject to all those statutory consequences of decertification.
okay. Thank you.
Thank you. Commissioner Calderon, I think you're next with your hand in the air, please.
Thank you. Morning. I'm going to direct my question as well to either Attorney Ravitz or Povich, whoever wants to answer. But if we look at page 5, which I believe is 7.53 BI. I'm saying it right. It's on page 5, everybody. To me, it just seems very awkwardly written, and I'm somewhat confused by what's being stated. So I'm looking for some clarification. Surely the people I represent are going to be asking me. Division of Certification rendered a determination that an officer possesses good character and fitness for employment, so long as it does not contribute to the appearance of a pattern of misconduct. An authority has the decision on the merits of the complaint alleging misconduct in the officer's favor. I guess I'm looking for an explanation, because wouldn't we be deferring to the third party that's already adjudicated the case? Or does this imply that even though the case has been adjudicated in the officer's favor, that the commission could override that and decide differently? Or am I misreading that?
I'm sorry that I couldn't find the section that you're referring to quickly enough, but I think that if I understand the question is does the commission still retain the ultimate ability to render a determination on character and fitness, even if it involves a certain form of conduct that was already subject to an adjudication by another authority? Is that right?
That's correct.
Okay. This as drafted, these regulations would allow the commission the ability and preserve the power of the commission to render an ultimate decision on the matter. And so that decision could be that that an officer lacks good moral character and fitness for employment as a law enforcement officer, where it's based in part on conduct that an authority where an authority has not ruled against the officer. So but at the same time, it also allows the commission to essentially defer to that ruling by that prior authority, and say, all right, that form of conduct is off the table. We're not going to take that into account. We're not going to hold that against the officer. But it doesn't require the commission to do that. It just maintains the ability of the commission to make the ultimate determination. And I think part of the rationale for that is that a determination by another authority regarding the conduct might not have involved the same question of whether the officer possesses good moral conduct and fitness for duty. Those two decisions might not be the same. They might not involve the same questions and the same considerations. So this preserves the ability of the commission to render the ultimate determination.
I hear you, but it sounds like double jeopardy to me. It sounds like a total violation of somebody's due process. It seems to me that an officer is going to be accused of something, is exonerated in an adjudicated case by a third-party organization, wherever that may be. And these regulations are then going to give the authority to the commission to decide otherwise, and then try and come to a different decision after the fact against the officer. Yeah, I don't see how that's possible. I don't understand why this type of question even gets in front of our commission after it's been adjudicated. I disagree with it. It sounds to me like it's a violation of somebody's due process. It sounds like double jeopardy to me. Something that I think we need to look at as a commission, because it should never get back to us. If an officer is accused of something and is exonerated, it should never get in front of the commission to begin with. So I raise that as probably the most important thing that I see in the regulations right away. There are some other little words and pieces that I know that you said we can discuss, but this is an issue, and it's going to be a huge issue for law enforcement officers across the Commonwealth. Well, once they've already had due process in court, the commission should not even get a look at it or have the ability to overturn some other third-party decision. I appreciate the explanation, of course, Attorney Ravitz.
Well, let me see if I could respond to that a little bit further,
Yeah.
and just using the double jeopardy analogy. So, in short, double jeopardy in the traditional context wouldn't apply where you have two different offenses that each have different elements from the other one, right? So if there are two offenses that have some similarities, but each one is a little bit different than the other one, you could still be convicted of the second one, even if you were acquitted of the first one. So so just applying that here, we could have a situation like that where, for example, there was certain conduct and it led to a certain charge before an authority, and the officer, it was found that the officer did not violate a certain rule, maybe because one particular element was missing. There was something that prevented it from rising to the level of a violation, but it's still the case that the officer did something wrong, exhibited some poor conduct, some poor character, some lack of fitness for duty. It's just that for whatever reason, the particular rule at issue wasn't violated. So now we move over to this process. You could see how in that situation, it could still be determined that that an officer, even though the officer didn't violate that particular rule, the officer does in fact lack good moral character and fitness for duty in law enforcement. And so, and really every situation is different. You know, it's almost impossible to contemplate all the situations where you could have, you know, that kind of prior adjudication and then a later assessment of character and fitness. And so this would preserve the flexibility to look at things on a case-by-case basis and to see, would the commission be evaluating the exact same thing that somebody previously ruled in favor of the officer on, or are they evaluating something that's a little bit different?
So I
Commissioner
understand.
Commissioner
Sorry,
Calderon, if I might just suggest that we will take to heart the comments that you're making. I want to underscore on the part of the commission the fact that we are attempting in every way we can to address all the due process concerns that you and other commissioners and members of the public have raised. I think to the extent that it is an issue in phrasing, we will between now and the next meeting attempt to remedy that. But I think on this particular issue, what I'd like to do, unless you have some further comments that you want to make, is I would like to also turn to other commissioners in terms of other questions that they may have.
Commissioner Henkel, if I could just respond briefly, I guess where I'm trying to separate the two, and thank you, I do want to continue the conversation for the language in the future. Understanding what Attorney Ravitz is saying, I'm just stuck on the fact that if an officer is accused of position A and is exonerated on position A, and then we're going to take into consideration a different position, B, C, D, or E, I would think that that is a separate charge that then comes in front of the commission. But given us the ability to overturn an adjudicated case is where I'm confused. So I look forward to the conversation. I just want to make sure I was clear on how I was presenting it. But by all means, let's give another commissioner the opportunity. Thank you.
Thank you. And so I turn to my fellow commissioners in terms of other questions and comments that they may have with regard to this draft. Commissioner Wynn, please.
Less of a question and more of a comment. Maybe we need to follow up with the training committee. But on the subject of successful completion of an examination, I think we might need to be a little more specific. Student officers take many examinations and dozens of quizzes during the course of their academy training. I think we need to be specific as to which one that is referring to.
Thank you. Our executive director, I think, also has a comment that he would like to make. Enrique, please.
Yes, thank you, Madam Chair. I was going to try to clarify a little bit the part from Commissioner Calderon. If I may, the scenario that he was perhaps alluding to could pertain to a lack of attestation. In other words, a chief making a determination about good moral character based solely on a prior authority's finding, and that the regulation that is written as Counsel Ravitz was explaining would then bring back the discretion to the commission so that we don't rely on the attestation of the chief only, if that's the only reason for the lack of attestation. But again, I think your point about clarifying that language is good, and we can work on that.
Thank you. Thank you. Appreciate it.
Thank you. Commissioner Bluestone, let me just go through any of the commissioners who have not yet spoken. Commissioner Bluestone, do you have any questions or comments on this draft?
Not at this time, Chair.
Thank you. Commissioner Cherry?
Not at this time, Chair.
Thank you. Commissioner Kazarosian?
Sorry, no, none at this time.
And Commissioner West?
No.
Thank you. And again, I think as our general counsel indicated, other questions and comments that the commissioners may have will be taken into account between now and our next meeting. And we will anticipate at the next meeting voting on that version that will be presented to the public in advance of the meeting. Anything further, Commissioner Ravitz, on this, General Counsel Ravitz, on this issue?
No, thank you.
Thank you. Enrique, did you want to say something?
Yes, just on the last point that you made, Chair, that we hope to bring them back after comments from commissioners to the next commission meeting and adopt and vote on them. We're going to be asking that you adopt them on an emergency basis so that they become effective right then and there. They will continue to follow the normal promulgation process as will be your discretion. But given the impending deadlines and the applicability of these towards the recertification is the reason that we will be asking that you consider them on an emergency basis at a subsequent meeting. And in the meantime, we hope that many of the people watching us provide us with comments, and that'll give us at least some ability to try to address them between now and the next meeting.
If I could just supplement the executive directors, several questions are been posed about are the draft regulations available. They are available on the post website in the meeting materials for this minute. So to the questioners who asked that question, that's where they can be found.
Thank you. And I think with that, I'd like now to turn to the next item on the agenda, the executive director report, please. Enrique.
Thank you, Madam Chair, and good morning again, commissioners. I'm joined by a number of key staff who've been working very busy, working on all matters relative to certification and regulations, as you saw. I just want to mention them briefly here. All the certification team, Stephen Smith, Brian Cooper, Gina Joyce, Mary Polgarin, the technology team, Maurice Myrie, Jamie Ennis, and of course, you just heard from Randy Ravitz on the regulations. I want to start give you my update on mostly focused around disciplinary records. We have begun or almost, we began and are almost at the completion of the process of aggregating and reconciling data. That's almost drawing to a close. Given this, we feel that it's necessary that we conduct one last step of data validation, and we're contemplating that we let each agency see the records that were submitted to us and were aggregated and consolidated to allow them an opportunity to see them and make any last corrections before we make them public. So that will mean a few more days, hopefully not many more than a couple of weeks of this data validation. And I'll explain in a moment why we feel this is also very important, this last step that we are now contemplating. We believe that we will be in a position to make the following type of records available. And those are that have to do with suspensions, terminations, resignations to avoid discipline, and other matters that relate to those three aspects that I just mentioned. In some cases, there are a few instances in which somebody may have been terminated and then later reinstated. And these are the type of records that we are contemplating should be made public as a first phase of what we will be making public, but again, require ultimate data validation from these agencies. The categories that I just mentioned amount to about 4,500 records, and given this, we believe it's doable to have some data validation within the next couple of weeks. But how we find ourselves in this with this recommendation is that there's two big issues that I want to call your attention to, and why we are contemplating only making available the records that I just mentioned. And that is that You may remember that the statute gave us very little time, and a lot of records began to flow into the general mailbox that included all kinds of complaints, small, large, etc. We then embarked on the process of promulgating regulations. They became effective recently, and commissioners will remember that there are a number of complaints that are not reportable to post. That message has, is being delivered, is being effective as per the regulations, but it was essentially not in place when people began submitting those disciplinary records to the Post Commission. And the question then arises, which is, if they were not to post, you are no longer requiring that these type of complaints be submitted to post, why is there a need to make those complaints that you now have made public? So that's an important policy question, one that we are not asking you to decide on today, but one that we believe we can, at a minimum, comply with the need to make records available if we focus on those complaints that are clearly reportable to post. And those are the ones that I just mentioned: suspensions, terminations, and resignations to avoid discipline. Because this is a much smaller subset, one that is of great interest by many people who have requested that information be provided and the public, we believe that we can provide those records to the agencies where they have them, have an opportunity to validate that data, and then shortly thereafter publish that data. We will then continue perhaps on publishing additional data as is being validated, but ultimately the most important part is a policy decision that will be on your purview as to whether to publish information that we currently have that we are no longer requiring, the type of information that we are no longer requiring that agencies submit to post. The other element of data validation that I also wanted to make you aware of is that since we started to get all of those records, there have been a not insignificant number of retirements or voluntary resignations, or people who are no longer with the force, and they were not terminated, they were not suspended, etc. So this becomes really a question as to whether a retired officer should have their past disciplinary record out in the public. That's another policy decision that I want to bring to you. I'm not asking for a decision today, but we know in the process of data validation that we have undertaken that there are those type of instances out there. And so the question is whether we would make any of those records public, and whether there's an interest, a public interest in making those public if the individual is no longer active. So as we embark on this last step of data validation that I mentioned, one element that we will be asking agencies to corroborate is whether the officer is still and has not retired. On the records that I mentioned, that is termination. Well, if they were terminated, they're obviously no longer in the force. But if they were suspended, let's say for some period of time, and they're still working, there may be the case in which some of those individuals have already retired, not dishonorably, but as a regular course, and whether there's an interest in making those records available. So before we make them public, we need that data. That's a big element of that, the data validation that I just mentioned. We'll be asking agencies to provide to us, and we can make, commissioners can make the policy decision at a later time. Hopefully I can have an update at the next commission meeting as to whether there's a desire to include those records or not as we publish those records. Let me pause there on disciplinary records. I know I I talked fast about this, but if there's any questions, I will take them now. Again, I don't anticipate decisions, but I can provide any clarification if commissioners have them.
Enrique, I thank you for that portion of your report, and I don't think I see any commissioners' hands on this one.
So I don't anticipate any publishing before the next meeting, so I will bring an update to you then. But again, we'll be in a better position to have done more validation on this last set of data that we want. The other part of my update that I wanted to mention is that as I have been speaking in front of, as we have been in front of groups, getting additional questions, mostly around recertification, we have come up with the idea that we will be providing periodic updates on a regular basis, potentially between now and the process of certification, potentially on a weekly basis. We will direct members who ask about this, members of the law enforcement community and members of the public to the website, but these questions continue to come up, and I think it's important to continue to answer them. In many instances, these are principles or questions that have to do with what has been discussed at a commission meeting or contained in a prior decision or a set of regulations. That's the reason for, from now on, putting out these periodic updates. The intent is, of course, to drive more and more traffic to the website and keep our website fresh, and that's always an ongoing project. But I just wanted to make commissioners aware that we continue to get questions like this, and one tool that we will use starting potentially as early as tomorrow, because I know there's questions relating to principles that we have just discussed here earlier today, to provide members of the public and members who ask those questions with a concise answer or reference to a place in our website or a particular section of a proposed or previously promulgated regulation. So that's by way of update. There's many important questions having to do with recertification. I don't necessarily have to get into any one of those questions, but suffice to say that there's a great deal of interest in how we're going to be requiring that those submissions be submitted to post. There's many logistical questions about how to log in and so on. And again, these are an important part of our work to continue to try to communicate effectively with the very large group of stakeholders that we have.
And again, thank you, Enrique, for that additional report. Unless there's any questions or comments from my fellow commissioners, at this time, I turn to Attorney Povich and the public comment and question portion of our agenda, please.
Thank you, Chair Hinkle. I will probably go in reverse order. There are a few questions about the executive director's report and more about draft regulations. So, and I will tend to identify folks by name as they would identify themselves at a public hearing, although this time we didn't say that. So there are a couple of folks who are anonymous attendees. But the first question is, has the policy on which types of disciplinary records be submitted to post made available through the website? And, you know, I guess I'll turn that to Enrique to answer.
I'm sorry, Lon, can you repeat that? Because I was
right. The question is, has the policy on which types of disciplinary records be submitted to post made available through the public website? I think the answer, I mean,
yes, the answer is no. There's, in terms of policy, there is what I try to explain, and let me take another crack at it. In my report was that the regulations that we promulgated and became effective require certain complaints be submitted to post from law enforcement agencies, but exempt certain minor complaints that have to do with minor matters that they don't be reported to post. And that has been in place since around March, after March, when we had the public hearing, and those regulations became in effect very recently. Now, prior to all of this, when we had to meet the date in the statute to collect all disciplinary records, all historically, by September of last year, people made their own assessments about it and then started to submit all of these records to post. We began the process of aggregating. I explained before that that has been a very involved process. And as we now are contemplating the prospect of making data available as is required, especially because now that it's in our possession, there have been a number of public records requests about that. The question surfaces, and it's a policy question, one that we have not decided on. We're not asking you to decide on today, but I'm just posing for the first time orally here today, as to whether it's in the public interest, in your opinion, commissioners, that we disclose all information that we currently possess that was not reportable to post, because that was clarified until recently. And I submit to you that it's a good policy question. There will be, I guess, two sides to that. And you might even remember some of the comments that we received when we promulgated the regulations. There were those who commented that everything should be reportable to post, even all minor matters. And there was the case to be made that we should focus on the matters that, likely elicit discipline and has a sustained or discipline of some matter. So I'm sorry that I have not worded that in writing, but that's the essence of the policy question. And I know there's a way to write that in a compact statement or paragraph, but that's the essence of the question.
Thank you. This a related question, and probably from the same questioner, says the recertification spreadsheet and instructions have been updated as of 5/12 on the web page. Can you identify what was changed from an earlier version?
Yes, and I've had these. This will be clarified tomorrow in what I mentioned, because I've been getting these questions a couple of times. We felt it was necessary to include the date of birth. I'm sorry, it was already included. The date of hire that was not previously included in the template. The reason is that we found through the disciplinary records effort that date of birth not included and date of hire sometimes included provided some challenges in us disambiguating the records. So there's a new data field that we're asking people now to include. There's also, we saw some early validation errors on the early submissions, and we have made the submission template a little bit more robust in terms of validating data. In other words, when you enter something in a field that requires a date format, for example, that you don't leave the field until a date is entered and not, say, a text. That will make our lives much easier when it comes to aggregating data. And that's the reason that we updated the template recently. Now, that brings up the subsequent question, which is, what about people who had already filled the template prior to this update? And what we're saying, and this will be clarified as early as tomorrow, but I'll say it today as well, is that if we're asking kindly that you consider using the latest template, because that will help us a lot in terms of data validation. But if the effort has been already too much or too significant, we will accept data in the prior template. And we might have to just, again, do some data validation as necessary.
Thank you. To folks who've asked questions, I will respond with a thank you as Enrique asked the question, not for any reason other than to get it off the list, it's getting a little hard to manage the list given the technology. So I will say thank you, and then I won't see the question anymore, and I'll know that we responded to it. So let's see. David Cook of the North Shore Community College asks, will each chief of the force there, will each agency be notified if they do not have disciplinary records being posted because the information they provided doesn't, I think, meet the standards necessary to post?
If it pleases the chair and the commissioners, I'll continue to answer them because I think I'm the person in the best position to do so. So yes, we will. The part of the process that I mentioned earlier as to data validation is that we will contact agencies that we need data validated from. I don't have an estimate as to how many agencies that is, but if we're focusing on, we're focusing only on agencies that had records with people that included suspensions or terminations, those are going to be the agencies contacted for data validation. That may be a lot of agencies, or that may be, you know, half of the agencies. I don't know exactly at that point, but we're contemplating exactly the way to make that available. And there's a couple of technology options that we have, and we'll be making that available very soon.
Thank you. Sarah Betancourt asks, what kind of data was submitted by local police departments that required data validation? Were there repeat names or other unclear pieces of data?
Yes, we had a template that we asked agencies to submit and follow. And for the most part, they did. But in some instances where it was required to submit, to say S for something that was sustained, maybe somebody submitted SUST, abbreviating sustained, or maybe somebody submitted spelled out the whole word sustained. So we needed to make sure that that was the same data, and we had to map out these type of different submissions into a common type data. There were instances in which there were multiple charges, for example, and they spelled out the result of each charge on one record. In other words, maybe they said NS, NS to say not sustained for 2 charges. So we had to resolve instances like those so that the data could be aggregated and could be uniform. That turned out to be, you know, an important effort in terms of reconciling that that data, so that we can have uniform data, and that's where we find ourselves.
Okay, thank you. We continue to get a decent number of questions. So a few people have asked that they cannot see who's participating in the Zoom as participants. It's a technical question. Is it possible for participants to see the other participants? And I will note that there are now 159 participants on this Zoom. I don't know if that's a Maurice question or an Enrique question.
I can take that one, and I'm going to correct myself from the last time, Attorney Povich. When because this is a webinar, the way that it's designed by Zoom, you cannot see participants because this is a webinar. That's by design by the company Zoom, not by us.
Yeah, but we choose this option as a way to manage the conversation. We're required to make the public meeting. We're not required to have necessarily a public hearing.
This is a related question to what we asked before. I'm not sure I understand, but for agencies, this is of an anonymous attendee as well. For agencies that submitted the complete disciplinary history, including all complaints received, regardless of how minor, as requested by post by the deadline, that now have public records requests for those files submitted, wouldn't those agencies still need to provide that complete submission to those requesting it, since it was a public record that was submitted to you, even though you no longer require these complaints?
I suppose that's a question for the local agency, one that the local that they could consult with their counsel. I don't want to speak for them.
Okay, let's see here. Trying to group these in a way that makes sense. A number of questions, well, I think I'll go to the top of the draft regulations. This first question from the large number of these questions come from Thomas Pratt. The first of the questions from Mr. Pratt, Officer Pratt, are that relate to the questionnaire. And if I could interpret it slightly, he says, I thought the questionnaires were not being sent to post unless the chief or the commissioner would not sign off on the good moral character and fit for duty question.
That is the case, and I was monitoring the questions on and off during Attorney Ravitz's presentation, and I think that came on as he was clarifying that that they must provide a reason when they don't attest to the good moral character, but that we may ask for a reason if they do attest to the good moral character. So that's not in conflict with the current guidance, which is that we're not requiring that you submit the questionnaire if you are attesting to the good moral character, but I suppose we could if we chose that as per the regulations.
Okay, Mr. Pratt's asked on a number, Officer Pratt, and I'm sorry if I don't have the right title. I don't know what rank Mr. Pratt has. He asked a number of times when they will get to be action by a court, and I assume this is on the recertification decisions after the actions taken by the commission. So there wasn't a lot of discussion on that, but the executive director, the general counsel might want to explain how the recertification decision actually gets before court, at what point in the process. Or I could answer that.
I could ask Randy to take a stab at that and Lon to expound if necessary.
Sure. There's a point in the draft regulations where it says that after a recertification decision or a decision not to recertify somebody or not fully recertify someone has gone before after it's gone before the executive director for further review, that the individual can seek a further hearing before the commission in accordance with 555 CMR 110, which are a set of regulations that the commission approved, I believe, at its last meeting. And so that set of regulations spells out what that process would entail. And it also includes a reference to the opportunity for judicial review under the Administrative Procedures Act, Chapter 30A of the general laws. So I think those would be the places to look to get the details on how that process would work. And I think that just based on my look at the questions and answers, I think that might respond to a number of questions posed by the same individual.
Yep, I think we're getting through, I understand it's Sergeant Detective Pratt's questions. So we've knocked those off the list as well. He has another question that says, who pays the officer if the officer has not been certified? I don't know when in that, I mean, I can see the timestamp, but obviously as officers, as Attorney Ravitz said, as officers continue to be certified, they continue to be able to do their duty and they continue to be paid. If officers at the end of the process lose their certification, I think that would be an issue for the local police department to decide how they deal with an officer. I mean, if an officer is not certified, they can't serve as an officer. So I think that would default to a local process. Feel free to, Randy or Enrique, feel free to correct me if I'm wrong on that.
Yeah, I think that's right. What we all understand from the statute is that that officer at that time would lose their ability to arrest people, conduct searches, and perform police duties and functions. And then that would be an ultimate determination of the local agency, how they can deal with that situation.
But the intent of the regulations that General Counsel Ravitz went through today is to keep people in a status of certification and serving as law enforcement officers until a final determination is made, as he laid out. I think that's correct, is it not?
Right. Right.
Okay, let's see. Another question from Sergeant Detective Pratt. Who looks at these regulations? Is there an independent board that oversees post? The post is an independent commission. The board, the regulations are available for comment now, and and will be promulgated as regulations and subject to a public comment period and the like. There is no independent board that oversees the post. Another question from the same questioner. It says, will the officer be certified while an arbitration, it says if, not while. Will an officer be certified if an arbitration is being heard? Perhaps Attorney General Ravitz can highlight that point, which I think he mentioned before.
Well, as I understand it, the question is if there's been a charge brought against an officer or there's an issue that's been raised with an officer's conduct and it's currently the subject of a pending arbitration proceeding, will the officer continue to be certified? And my answer to that is that I can't say that the commission would in all circumstances take one approach or another. It would have to be dealt with on a case-by-case basis based on what the underlying conduct is. But there's again a part of the regulations that says that when the commission is evaluating character and fitness, the commission may look past a matter that is currently pending in making its assessment of character and fitness, so that it could still find that an officer possesses character and fitness even if there's an arbitration proceeding pending. That's as far as those draft regulations go in answering that question, I think.
Thank you. Aaron Garcia asks, do we include brand new officers that are in A through H who just graduated in these recertification submissions? That's a form of a question. I believe the answer to that is no. They have 3-year certifications from the date that they were certified. If I understand that.
That's correct. If they obtain a certification from post after December 1st of last year, they do not need to be recertified this time around.
And their certification this is really just to get through the folks that were certified by certified by statute because they were serving at the time.
Correct.
Going forward, everyone will have a 3-year period if they're a new officer from their date of certification.
Correct.
Correct. An anonymous attendee asked if the commissioners are considered law enforcement. Did they go through the certification process? The answer to that question is commissioners do not get certified under that process. Let's see. Okay, they're getting a little random now. So,
Alon, if I could just, because I think those of us who are still serving, so I think there's a little confusion for folks like myself.
Yeah.
We do go through the same process as those of us that are law enforcement.
No, you are law enforcement as well as a commissioner. That's a better answer, Commissioner. And thank you for that. This is a question on the hearing officer function contained in the prior set of regulations approved. It says, if an officer appeals a decision from an initial hearing, what will the size of the commission be? Will the officer and their attorney be allowed to be present for the entire case? General Counsel Ravitz, you want to? Or would you like me to do that one? Randy, you're muted.
Yeah, thank you. Could you just repeat the first part of that?
Sure. When an officer appeals from an initial,
Okay.
from a single commissioner hearing to get a hearing before the commission, what will the size of that commission, what will the size of that set of people who hear the appeal be? And will the officer and the attorney be allowed to present their case? I
If
think
it,
that relates
if,
to the prior regs, not the ones we did today.
right, if it goes before the full commission, then it would be a quorum of the full commission would be required to take any action. And so by statute, that's 7 commissioners.
Let's see if I got that.
I could expound on the latter part of that question, and it's the discretion of the chair to, of course, receive testimony and have members present on a hearing like that.
Robert Bosquet asks us that section 4 of the post statute says the commission shall not issue a certificate to an applicant who has been convicted of a felony. Does this mean a current officer who had a guilty, maybe that's plea, it says guilty file for a false motor vehicle document in violation of chapter 9024B, which says inspection stickers from years prior will not be able to certify? This is a very low level felony, but should we be concerned for an officer who used a fake ID in college 25 years ago?
Well, I will just say that the statute doesn't include any provision that limits the time in which we have to, look back at prior felonies. So it just says that if an officer has been convicted of a felony, that they can't be certified.
Okay, let's see. Maria Padilla asks, will waivers be considered for recertification? I don't think there's any process in the statute for a waiver, but I leave that to.
I don't either, and I know that we have not drafted that in regulations. There's
Okay.
a process that mirrors sort of, how to follow different paths through the recertification, but not a waiver process.
Another question on public records from someone in Seekonk says, how should agencies respond to public records requests by media for disciplinary records, for the disciplinary records that were provided to the commission? If we do not know what will be released, publicly, I do not feel comfortable releasing officers which may not be released by the commission. I think that's sort of a coordination between Post and the locals on that.
Well, I feel that I answered that question, a version of that question earlier, that this is something that locals need to determine.
Thank you. Okay. Sorry. Sergeant Detective Pratt asks, when someone makes a complaint against an officer, will that person make this allegation under the pains and penalties of perjury? And will the complainant be made available for the deposition, for a deposition, or for deposition? I do not believe that the regs that were approved by the commission at the last meeting require complaints to be made under the pains and penalties of perjury.
That's correct.
Does anyone want to take a swing at the deposition question? There's no, that is neither in nor out of the regulations.
That's correct.
Right.
That's correct.
There's a question that says the Mass Chiefs of Police sent a letter to the commission last week with a series of questions regarding recertification process of the questionnaire. In what form or format will we, I assume that means the Mass Chiefs of Police Association, receive feedback from the commission?
Well,
Well,
if I might respond to that question, I received on behalf of the commission a letter which actually came this week, not last week. And some of the answers to those questions have been addressed in terms of the material that have been presented today. Other portions of that are likely to be addressed in what Enrique commented, maybe on the website within the next few days. And then in terms of whether there will be a more specific response, we will address that. We simply have not yet had time to address some of the questions that have been raised in that letter, but we will do our best to, in timely fashion, respond to the inquiries that have been raised in some form or another.
Okay, now we have a short series of questions, set of questions, basically around consequences for failing to follow the commission's process. So, I'll give them as a group, and the commission can decide how to answer. Chief Timothy Kane writes, "What does the Posts Commission plan to do if an entire agency refuses to complete the required questionnaire?" Scott Hovsepian asks, "I may have missed this, but if an officer does not fill out the questionnaire, will they be decertified?" Maria Padilla asks, "Can you explain the consequences, sanctions, future oversight, fines, etc., for failure on agencies or administrators who not submit according to the law and follow up dispositions?" I think those are sort of a set of questions.
Let me take the collective questions about participating in the questionnaire or not, or as first. Our current position is that if an officer refuses to participate in the questionnaire, then the standard of an oral interview will not be met, and the officer will not be recertified. Now, if they don't answer one or two questions, that may be a different story. But the standard, that's the guidance that we're issuing on participating on the questionnaire.
Okay. Let's see. Another question.
And by the way, one of the questions said decertified, and this is where we do the distinction. The officer will not be recertified if they don't participate in the questionnaire, and then the things that follow will follow.
Okay. Maria Padilla comes back with, "For small departments who don't have an internal affairs division, but internal controls such as HR, Title IX, what is the legally accepting path for addressing original complaints, not the resolution?"
I'm not sure I can answer
I'm
that
not sure I
question.
understand that question either. Jay Carroll asks, when will the commission answer the joint letter sent from Pyle Rome dated May 3rd? I think I assume that's the letter that relates to the ongoing litigation.
That is correct.
I'm not sure it calls for an answer outside of the litigation.
Correct.
Another question on the questionnaire says, "Do you plan to consider amending or eliminating some of the questions that are viewed as beyond the scope of post?" I assume that's also involved in the ongoing litigation, so I don't know if the commission's in a position to answer that at this time. The last question we have, and I think we'll call it to a close at this point, and thank you all very much for the questions, is a question from Bill Ragan saying, how can I best assist the commission as a citizen?
Well, submitting comments, asking these type of questions, writing to us, and if it applies, I hope it doesn't, but if it applies, that you submit a complaint to the law enforcement agency and or post.
And the last person following up on Sergeant Detective Pratt's question about complaints being signed under the pains and penalties of perjury. I would say on behalf of that commission that that question and that suggestion was considered by the commission when it promulgated its first set of regulations, but is not included in the regulations as approved by the commission at its prior meeting. I think well, sorry, one more question just came in. I don't want to cut anybody off, but this will be the last question if we could, please. A previous question was asked regarding decertification during the arbitration process. This new question is based on arbitration. If an officer is disciplined for an infraction that would normally decertify the officer, but the officer completed the arbitration process before post was notified and the discipline was overturned by the arbitrator, can the commission still decertify? I think General Counsel Ravitz answered that type of question, but if you'd like, Randy, if you want to reiterate what you said.
I don't think I have anything to add.
Okay. All right, thank you all very much for the questions. We responded to approximately 50 questions during this session, so we appreciate the feedback and the input.
Commissioner Bluestone has had her hand up. I don't know if it's related to one of the questions, Commissioner.
Yes, thank you. It's just, I think generally, I'm wondering if it might be helpful to clarify a little bit more broadly sort of the way that the post commission was designed to be independent and to include both civilians and law enforcement members to represent really diverse perspectives, personally, professionally, and geographically. With the goal of being able to bring all of our perspectives together to these very difficult problems. And I think what I hear in the questions is just a lot of fear and concern about, us not understanding the law enforcement culture and some of the issues that they're facing. And I just think it might be helpful to state that we're, many of us are not law enforcement officers. Obviously, we don't go through the same credentialing process, but we did all go through a rigorous process to be appointed to this position. We take it very seriously. And certainly we could be dismissed as well if our conduct were unbecoming. So I just wanted to add that point.
And let me underscore Commissioner Bluestone's comments and speaking on behalf of all the commissioners who have put in an extraordinary amount of time and energy in addition to their regular positions in attempting to meet the very aggressive goals that were set by the legislature and to do it with adequate concern for protecting all of the due process issues that have been referred to earlier. I also see Commissioner Ellison's hand in the air, so let me take his question.
Yes, thank you, Madam Chair. I'll be brief. Just want to address the gentleman, the individual who asked if they could be of assistance, and thank them for offering. Is that, there's a lot, as Commissioner Bluestone stated, there's a lot of confusion. So if he is in attendance on meetings such as this, and if he could pass along the information that he gets from this as clear as they could to the public as well as to law enforcement who are not in attendance, that would be helpful, because that is a lot of it, was Commissioner Bluestone alluded to, is messaging in fear of the unknown and people who aren't able to attend these meetings. So that would be a very helpful process if he could pass along what he learns at these meetings.
Let me also thank the staff who has worked extraordinarily hard, Executive Director Zuniga, our General Counsel, all the other members of the staff over the course of the last months since they have become employed by Post, for all the efforts that they've been involved in. I think with that, I do not know of any matters not anticipated by me at the time of posting. I will now entertain a motion to go into executive session to discuss strategy with respect to the litigation, because an open meeting may have a detrimental effect on the litigating position of the Post Commission. That litigation is the civil action of Hovsepian and others versus the Massachusetts Peace Officer Standards and Training Commission, which is currently in Suffolk County Superior Court. A majority vote by roll call is required for us to go into executive session. The open session will not reconvene at the conclusion of the executive session. Let me now call for a roll call vote. Commissioner Bluestone, do you approve going into executive session?
Yes.
Commissioner Calderon?
Yes.
Commissioner Sherry,
Yes, I approve. Yes,
Commissioner, thank you. Commissioner Ellison,
Yes.
Commissioner Kajirosian,
Yes.
Commissioner West,
Yes.
Commissioner Wynn.
Yes.
I also approve it. The motion is unanimously carried. With that, this open meeting concludes. Thanks to everyone who has participated in any manner with regard to our meeting today.
Thank you.